Hi and welcome to the JA Malta Podcast. Today we're discussing contracts, employment contracts. So after seeing the process of someone searching for a job and going to interviews, we are now discussing what should a candidate, a job seeker, look into a contract. And here with me today I have Roselyn Borg and 𝗟𝗶𝗀𝗁𝗆. So just introduce yourself, Roselyn, first. Quick introduction.
Hi, I'm Roselyn. I'm an employment lawyer and I absolutely love what I do.
Excellent.
Hi, 𝗟𝗶𝗀𝗀𝗆, also an employment lawyer, amongst other things. Also love what I do. I'm happy to be here. Thank you for having us.
Excellent. Thanks for joining. So today this clip here, this podcast will be a bit more technical than the others because obviously we have two lawyers. So we have to be careful what to say. We start off with a quick fire round question just to break the ice a bit. So when you're seeking clarification or getting in touch with someone, do you prefer email or phone call?
Phone call.
Email.
If you're planning things and have a diary, pen and paper notebook or an online calendar?
Online.
Online.
Reading through documents, a quick glance over key points or reading it slowly and surely?
First quick glance.
Quick glance, but slowly and surely, definitely.
Flexibility in working hours or the standard 9 to 5?
Mega flexibility. Love it.
Standard 9 to 5.
Networking on LinkedIn and online or in-person events?
I love meeting people.
Same, person events.
Ready-made meals or homemade cooking?
Home cooking as long as someone cooks for me.
Home cooking.
I like that.
Being a lawyer subject to.
There's always
Provided that.
proviso. Exactly. So, as I said in the introduction, we're looking at employment contracts now. So, Roso or 𝗟𝗏𝗀𝗏𝗆, just to see who wants to go in first. What type of contracts are there? What different types of contracts exist? Or how would you classify different employment contracts?
In short, no, definite, indefinite, full-time, part-time.
Exactly.
Those are the two main classifications.
And when it's definite or indefinite, what is the difference? Is there a termination clause or what?
I think it's important to also explain because some people know the term definite as fixed term. So what does definite mean? Definite it is for a period of time which the parties are agreeing to. Whilst indefinite, it's forever. Okay, subject obviously that people can resign or they're terminated due to redundancy, etc. I think the main difference that a lot of people, 𝗟𝗏𝗀𝗏𝗆, I think you would agree with me, one of the most common queries we get is that people are not aware of the implications
Of the two.
The definite period brings with it a very serious consequence. So if one of the parties decides to terminate before the term expires, the party who terminates before, unless there is a good and sufficient cause, has to pay half the remaining period. So a lot of employees, unfortunately, get into these contracts
blind,
not knowing that there is this penalty, and then they try to get out, and there is a lot of issues.
Okay, so what is the benefit then of a definite contract in that case?
Well, it depends on the situation, right? So there are situations which would necessitate having a definite contract. So if you need someone in a certain position for a short period of time, say a summer job, that is a clear example where one can apply a definite term contract. There are other benefits. Now, do employers use them correctly is a different question. So you get a lot of cases where definite term contracts are used to prolong the probation period, for example. So we have a standard 6-month probation period. Employers would sometimes offer a 1-year contract, for example. And over there, they're using that to sort of bridge the gap between the 6 months and the 1 year and give them more flexibility. And then potentially confirm the employee beyond that point. But recent amendments have also amended the probation periods that can be applied during a definite term contract. But maybe that's branching out a bit too much. But
and when you say, just to make sure everyone is clear, when you're saying probation period, what happens in the probation period?
I think what Edward is trying to say, the employer, when they have a definite period contract, they have a chance to terminate the relationship, right? Without having go through the saga of potential disciplinary or potential performance improvement plans. An advantage for the employer is the fact that sometimes, especially in manufacturing, where you have an order book which is not predictable, they tend to give definite periods because then it depends on the work, so they can't commit indefinitely. Going on to probation, I think Edward would agree, it's one of the topics that everyone really needs to understand. If there's something in employment law which everyone needs to know is probation, because probation is the only time when the employer can terminate without giving a reason.
Same for the employee?
Same for the employee. Okay. But for the employer, it's in a way more important.
It's a tool in the hands of the employer.
It's a tool, because at the end of the day, once probation is over, then it's a matter of having this very easy word, but in practice, to implement it is very difficult, the good and sufficient cause. So probation is a very important aspect of the employment relationship. Now, some employees, when they're getting their contract, what they need to look at is the length of the probation period, because during probation, they're not really safe, right? Because the employer can wake up and tell you, listen,
it's a get out of jail free card for the employer. So it can be terminated, no reason given, and employee has no leg to stand on.
Exactly. So in that case, the length of the probation period is very, very important. Key. It's key. It's one of the things I would look out for if I am advising on a contract of employment. The other aspect is you cannot just give a probation period of, like, for example, 1 year. That 1 year is only in particular circumstances. If you have a managerial, executive, technical, administrative role, and the wage is at least double the minimum wage. So it's very particular when you can give the 1 year probation. Yeah. But again, even though the law allows for a 1 year probation in that instance, it's not the first time that the employee in the stage of getting the contract negotiates for a shorter probation period.
In fact, that would be one takeaway point from this, which is, negotiation isn't always on the numbers. Negotiation can be on the conditions of work as well, where employers are more willing to give, a bit of space over there. So, because there's no cost in effect upon signing. So one may negotiate, for example, if they're faced with a 6-month probationary period. If they don't bring it down to 3 months, they can request, for example, a review after 3 months and potentially bringing that down and confirming employment at that point.
That's and another important clause I feel in a contract is the notice period, on the other hand. So could we dwell into a bit the notice period? What is it, and what does it usually cater for?
Sure.
One of the mistakes we find in contracts, because people use templates and they copy and paste. Sometimes, without knowing. Sometimes you have the notice period clause in a definite period contract, which is wrong, because a definite period is for a defined period of time.
Without notice.
Okay. Except during probation.
This is in Malta, right? Because, for example, in the UK, you have 5 types of definite period contracts. But in Malta is... I like to compare because other countries do things differently. So basically, what I was saying is that the definite period contract would not have a notice period clause, whilst the indefinite period, so the forever one, I like to call it, would have a notice period. Now, the notice period can be according to law, okay? And sometimes the parties agree for longer notice periods, but that's again...
Same as the probation, no? The
employee would want to... It's a double-edged sword in reality, because if you're being made redundant, for example, it's to your advantage that you have a long notice period clause. If you are, for example, resigning and your new employer wants you quick, it could be a disadvantage. So it's a bit of a tricky one. Yep. But at the end of the day, it's not the first time that employees agree to a long notice period clause, because in practice, we do negotiate at termination stage to waive the
especially
notice.
if you're on good terms with
if
the
you're
candidates.
amicable, if Edward and I are against each other, for example, we try and tell each other, let's be reasonable, and let's try and see what's best for the company. In my opinion, and I'm very, the type to like to give my opinion, I'm not very keen on long notice periods, because I believe this is like when you're going out with someone.
It's a breakup.
When you break up with someone, you just don't want to keep seeing them. Well, it depends if you're still in love with them or not. But in truth, the relationship has. I'm leaving
broken,
because I want to move on. So if I want to move on, why are you going?
Why
to
are you keeping me here?
Yeah.
The one situation where a notice period could be useful, for example, is where, just to take a bit of a step back actually on this. So the notice periods are set out by law. So there are standard notice periods, and then you can agree to the longer notice periods in cases of managerial, technical, executive, administrative roles, double the minimum wage, etc. So when you have someone who has a longer notice period from day one, generally they're in a higher position than someone who would have the standard notice periods apply. So over there might be exposure to certain information, certain clients, etc., etc. So the employer would almost have an interest to safeguard that information. So one way of using a notice period, for example, is by keeping the employee on the books on a day-to-day basis, so for the full notice period, and telling them not to report for work. So the concept of garden leave, for example, in the UK. So that is where it can be a sort of useful tool. So although there is a breakup and agreed that in certain positions it's better to sort of say, no need to report for work, I'll pay you for your notice period, because that is the employer's
to avoid any
prerogative.
risk of leakages and the notice period, it doesn't apply during the probation. So probation is an immediate termination.
No, there is a notice period.
It's 1 week.
It's 1 week after 1 month of probation. But again, if the probation is for a year, and you have the standard notice periods, and that I believe goes up to 2 after 6 months.
But there's an anomaly in the law over there, because
there are quite a few of those.
Because we argue which applies, the provision of the 1 week or the provision of the notice period, because there's a bit of a question mark around there. But again, the employment law, I think Ed would agree, a lot of it is, as much as we have laws, a lot of it is what happens in practice. It's
most of it is.
It's that kind of law. You're dealing with human beings. You're dealing with people's lives.
So it depends also on the relationship between the two.
And a lot of grey areas.
There's a lot of grey areas. That's how we make money, actually.
That's the fun part of it.
Exactly. Finding the loopholes in the grey areas.
So,
like most EU law, really.
Moving to other clauses, other important clauses, is other working conditions. So what should an employee look at, apart from the probation, the notice periods, any other important clauses you would highlight as someone to really dig deeper?
Overtime, I think, would be a...
That's a tricky
one. That's a
tricky one. Yes, because again, this is again a bit of a pain, because a lot of contracts have the standard clause that your salary is inclusive of any overtime. How legal that is a big question mark, because in truth there are also regulations regulating overtime. But again, it's practice. So practice tends to dictate that when it's a higher end salary, it's acceptable. When it's a lower end salary, it doesn't tend to be acceptable. But we need regulations around that. I believe that it's still not clear.
So is this something that the employee should actually bring up in an interview or while negotiating the contract to clarify these details?
Yes. I mean, there's always going to be that balance. You don't want to come off being the employee or the potential employee, don't come off too strong in those negotiations, but you also want to establish a level of clarity, right? So
Agreed.
I think getting that advice independently would help. So the employee then is fully informed of what the contract states and what his or her rights are. Again, when it comes to employment law, generally speaking, the minimum conditions, the basic conditions of work are set out at law. And the law also states that the more beneficial would apply. So if the contract is more beneficial to the employee, the contract is going to apply. If the law is more beneficial, the law is going to apply. So there are certain things which might not even be worth bringing up, because if the contract says
it's too strict,
10 days of leave when the law tells me I have 20 is going to apply regardless of what the contract says.
Agreed.
And there's no point in arguing that potentially at the beginning of the relationship, you know, but as time goes on and as one proves themselves to the employer, whatever, then obviously that conversation becomes a bit easier.
Excellent. So moving on again now to the leave. You mentioned leave. Are there any special conditions that we should be aware of? For example, a question I have I get from a lot of young people looking for the job for the first time is about shutdown. Shutdown is taken from their annual leave, right? It's not extra days. No. It's just forced leave.
It's different.
Any limitations on that, or how would you define these?
First of all, because again, it's a word which is used interchangeably, shutdown and forced leave, but there's an actual regulation on annual leave which makes a distinction between shutdown and forced leave. Shutdown, you need to notify employees, if I'm not mistaken, by the end of January, and it is a period where the company is going to be shutting down, basically.
Maximum of 12 days.
There's a maximum amount, and it's in practice it's normally over Christmas or the Santa Maria period in practice. And then forced leave is when the employer, for a justified reason, puts employees on forced leave. For example, we used it a lot during COVID. You know, we put employees out on forced leave. They're still being paid, okay? But they're not happy, the employees, because you're imposing it.
And it's taken from your annual leave.
Yes,
again.
but that's not something a forced leave situation is not something you're going to read in a contract of employment, because it's going to happen if and when it is necessary. And again, with regards to entitlements, be it annual leave, be it sick leave, be it whatever, it's normally in accordance with the law. So it's normally not something that some employers tend to write it in the contract.
There's a lot of leave, huh?
but there's a lot of people just do in accordance with the law and leave it. And leave
which
it
is fine.
Yes.
Which is completely legal.
You can do that as well.
That's technically the law, that's why it's there.
Yes, and you'd also find a lot of information. So when it comes to leave entitlements, for example, the DIAR, their website sets out minimum conditions of work. So it's good to familiarize. To be familiar with what entitlements one may be entitled to there.
Excellent. So just to again have a bit of a break from the technicalities, we in our podcast we typically stop a bit, have a bit of a break for a funny incident, let's say, and maybe you could be able to share something with us, and sort of in your work when you're negotiating with employers or employees, or random questions you get asked that could be of entertainment for the rest of us. Anything to share?
To be honest, contract reviews and contract drafting are not the most exciting things one can do. Yeah. But having said that, I think for me, because sometimes I'm just really busy and I'm really terrible with technology. So sometimes you're having an online meeting, you're thinking you're advising on the contract of John, for example, and in front of you have the contract of Peter, and you're thinking, and the employee is going, but I didn't read this clause, you know, or else you wouldn't have had time to review it in detail. Yeah. And they go, what about clause 6? What the hell was clause 6 say? Okay, so you have to
so you're caught by surprise.
Yeah. Yes. Or you say, they mention a clause which isn't there, and I'm not following, but do I bring it up or do I just pretend?
Exactly.
Let's see how long I can stretch this out, you know, but if you get caught out later, then it's...
But I think when you have enough experience like Ed and I have, you tend to manage the client, you know. And one thing I've learned as well is managing clients' expectations. I think that's one thing I've really learned. Yeah. Sometimes you want to satisfy the client by saying, I can do it for you quickly. No, you know, you need to say, listen, I'm busy this week, can it wait? If it can't wait, I'm going to send you somewhere else, you know, because sometimes these things, people do not understand that these things take time. Yeah. Again, with experience.
Quality takes time in general.
With experience, you review quicker. I'm not going to lie, you know, today I know exactly what I need to look out for in a contract. If I did it 20 years ago, I'd be reading every line. So I think clients need to understand that things do take time, you know. And what frustrates me a lot, I have to vent, is like they want a template. It's not just a template, it's you have to adapt the template to what the...
Yeah. Like we tell employees to update their CV or adapt their CV and introductory email, we are saying we expect employers to also update the contract and adapt it to the different roles rather than just using templates. Thanks for that, Ros and Edward, for that quick break. We'll move back into another different clause this time around in the contract, because we have a lot of ground to cover. We mentioned the aspect of confidentiality, sensitive information. what is the typical scenario you see in contracts when it comes to confidentiality and non-compete? It's something also quite interesting to discuss. Could you guide us through what to expect from a confidentiality point of view in a contract?
I think at a basic level, you have to see what the position is, right? So it depends on what exposure, at least, is expected within the role. I mean, I've seen confidentiality and restriction clauses which were 2 pages long, Nasib. So again, it depends on the role. It also depends on the sensitivity, the value that's attached to that information for the employer. But the bottom line is, I think the weak spot there, the Achilles heel, is enforcement. Being able to enforce a confidentiality clause, obviously, if you have a claim, you have to prove it, right? So if my claim is you've taken my information and used it for your benefit, I somehow need to prove that. And that's where we get stuck a lot.
Because it's I'm gaining experience, so obviously I'm going to use it elsewhere. So we need to differentiate between what is knowledge I gained as a skill and knowledge which is sensitive information.
That's right.
But I think, Matt, there is a lack of awareness amongst employees in the sense they don't sometimes realize the value of information. Mm-hmm. And some employees come to you and tell you, I actually asked them, did you ever forward something from your work email to your personal email? Obviously I did. So I keep things, not I drafted it. And it wouldn't be done with malicious intent.
Not always.
Not always. I try to be the one that thinks always gives
the benefit of the doubt.
But unfortunately, it comes from a lack of awareness. And I think it's good that we're talking about it. So employees need to be aware that what they think potentially is nothing or theirs could actually have consequences. Mm-hmm. I mean, we've had cases of employees getting dismissed because of the fact that they took confidential information which they weren't meant to take. And besides the contract of employment, sometimes because we're talking about a lot about the contract, sometimes there are also separate non-disclosure agreements. Sometimes we have a handbook we need to look at, policies and procedures about how you should handle email communication, how you cannot forward stuff, how you cannot take things. So I think this lack of awareness, in my opinion, is my biggest concern.
And there are, sorry to stop you, but there's also the law. So directors, for example, have fiduciary what are called fiduciary obligations, which is inherent within their role, which means that they always act for the interest of the company, which a byproduct of that is not doing anything to harm that company, even after they've left.
Yes, because we need to also keep in mind the other policies, like the use of devices. Because if I'm using my phone and I have emails on my personal phone, automatically they're on my phone. So I need to be careful how to manage this from an employee point of view.
And another interesting aspect, I tend to digress, but it's because it's interesting. Confidentiality also, we saw more implications because of remote working.
Cool.
So if people, for example, are working from a coffee shop or from the beach or wherever, it's amazing. I'm all for this remote working. I'm more of a believer of hybrid working because I think you need a bit of connection.
Even a phone call?
A phone call. Sometimes people lack the awareness. So as well, we need to look at policies that deal with remote working, because in those policies, normally you have as well provisions dealing with how you should handle information. So I think it's a matter of educating employees. And in my opinion, where employers go wrong is that they assume that employees know. You cannot assume, especially if it is your first job, or you're very new to the world of work. Some things, unless people tell you, you're not going to know.
You won't be aware of it.
So I think the education also has to come from the employer, because we talk a lot about the employee, but it's also the responsibility of the employer to ensure that the employee knows what they're signing for. And another piece of advice, if I may, a lot of employees come to us when there is a problem. And you're thinking, if you came to me when you signed the contract, I would have given you advice at that point. Because some employees are keen, especially if it's the first job, because we're talking to the young generation here. They're keen to sign, keen to get going.
And sometimes they also feel like they're the weaker party as well. So they need the employer more than the employer needs them.
Yeah.
And sometimes it's also about, because earlier Edward as well was mentioning the negotiation of the contract. I'm a big believer of how you negotiate.
Yes.
It is not a matter of saying, I don't want this clause. It's a matter sometimes of how you word it, And before I said phone, not email. Because sometimes I believe when there is a tone to something that you're saying, you can express yourself more. So I always tell them, why don't you call and say, can I have some clarity on these clauses because I'm not sure I'm understanding rather than going and saying, I don't want this clause, it's too severe, it's too much, I don't like it, I got legal advice.
No, the approach needs to be constructive.
Yes.
Yeah.
It shouldn't be confrontational.
Like you mentioned, it's a relationship.
Yes.
So you don't come off with a bad impression from day one. It's very difficult to get over that bad impression, even if it's something that you didn't intend to do.
Yes.
So it's always good to be constructive, calm. As Ros is saying, the tone is everything.
So in case during my working time, my working hours, I'm creating something new, a new document, a new procedure, a new program, whatever it is, who will be the owner of that IP, of that intellectual property? Will I be the owner, or will the employer own that new program I created?
Okay, so this is a conversation that can go on for hours, but at a very basic level, copyright law would say that is the work of whoever has employed you to provide it. Of course, again, it depends on context. So there's work where there's a lot of IP which is created, a lot of intellectual property, a lot of copyright work. So computer programmers, for example, is effectively pure IP. So the work they are contracted to do through their employment contract is for their employer, who would be servicing a client potentially, but it is all within that context. If that programmer goes home, creates a piece of software which is completely detached from their job, then there's a difference there. They're not paid to do that. That is their idea. That is what they've created. But again, then the area sort of blurs a bit, where you have an idea where the employee has gotten from work, goes home, develops it further, and then creates a product that can be sold and potentially compete with his employer. So you get different scenarios depending on where the employee is, who he's or she is doing it for, and what they are doing.
So this starts bringing things together. There's the non-compete, there's the ownership of information or programming that we did, and also the concept of side hustle or work apart.
That's right.
Should the employee bring it up that they're doing work elsewhere, or they're planning on having their own business at the side, a small side hustle? How should that relationship be handled?
A recent law, which is the Transparent and Predictable Working Conditions, caters for this. And basically, in summary, what the law says, employers cannot prohibit employees from doing other work, subject to that work cannot be in conflict with what they're actually doing with the employer, and there isn't an impact on health and safety. Having said that, I believe that employment is beyond law. It's about relationships, so honesty is key. So in my opinion, if an employer and employee have a transparent and open relationship, it's going to be much better. So my advice is there's nothing wrong in sharing with the employer, especially if you're doing nothing wrong. Yeah. So at the end of the day,
all cards on the table.
All cards on the table, because Malta's small anyway, people are going to find out. And at least there is clarity, because if, for example, Edward was mentioning a blurred situation, maybe the fact that you speak and maybe you put in writing where the boundaries are, where the what is mine, what is yours is created, then obviously you're going to avoid problems in the future. You mentioned the word non-compete. I think when it comes to those kind of clauses, Edward, again, hours could be spent on restrictions. We call them restrictions. How much can you restrict someone from working from a competitor? I think these clauses are very difficult to enforce. They are clauses which need to be drafted very, very well. And I would also say that people would need to look at clauses dealing with non-solicitation. So you can't solicit employees, you can't solicit clients, you can't try and steal the suppliers that are of the employer. So
going back to that argument of understanding, being upfront with what you're doing, and really trying to keep boundaries between what is work that I'm doing with my employer and what is something else that I'm doing at the side from my end.
As a general rule, I think that the key here is to be, a lot of common sense comes into it as well. So, we know what is right and what is wrong. At a very basic level, you know what you're doing right and what, if you do something, what is wrong, right? So there are interests on both sides. There's the interest of the employer and the interest of the employee. So those need to be balanced. And this is what we tell clients as well, but on either side. So it is important to have non-competes, both during the lifetime of the contract and even once it's done. Because there are interests, again, depending on the position, but there are interests which need to be safeguarded. At the same time, you cannot stop that individual from seeking other work, applying their skill set. At the end of the day, that is what fulfills a person. So you cannot tell them, I'm sorry, but you have to work as a shopkeeper for a few months because you cannot work as a programmer with anyone else. It just doesn't work that way. So the key here is balancing interests and at the same time making sure that people are doing what they should do at the end of the day.
The fine line is obviously if I get ideas and I develop them separately, which are very close to the work I'm doing,
Exactly.
and that there becomes a bit blurry.
Generally speaking, these sort of clauses act more as a deterrent. When it comes to enforcing them, the relationship has broken down, there's no trust, and then pride also tends to play a part in it, which is where things go really off. Because
Agreed.
then it becomes a race to the bottom.
There's no logic then.
Exactly.
It becomes a bit
emotional, and when you're emotional, you tend to make very wrong decisions.
Exactly. And very expensive ones.
We benefit from them though.
Yes, but
So this is an interesting point. So you would get clients both as an employer and an employee. An employee can actually seek legal advice before signing any contracts, or also when there's any issues that are being raised, there is help available for them to seek out advice.
And definitely recommended. So it should be both ways. Both the employer and the employee should go in with it eyes wide open, full of knowledge as to what they are signing. It's a contract. And it's going to regulate a relationship that could last a year, it could last 20 years. So
something else I wanted to point out, maybe the last comment, a lot of individuals seeking new employment or starting up, they want to see the career path or some progression, some training, development. Is this something that should be in a contract, or typically you don't see these things in a contract? Sort of what
you tend to see training mentioned in a contract, but personally I'm more in favor of training agreements being separate to the contract of employment, and even employees need to be aware of this, because if you have a generic training clause in the training in the contract of employment, it's not going to be specifying the cost or what the training is. So personally, if I am looking at a contract from an employee side, I would tell the employee, get more information. Ideally, ask for a separate training contract in the event that specific training is being provided. Because normally, together with a training clause, you would have consequences, right? Because this is going to cost money, and there would be
investment.
There would be even a cost implication that if you leave after 1 year, you have to pay 100%. After 2 years, you have to pay 75%. It's a scale normally. Again, this is not something regulated in law. It's something which is practice and which is drafted in a training agreement.
Agreed. Okay.
So yes, these clauses need to be looked at closely.
There's also training, no?
Exactly.
You get courses and you get one-off training sessions, which is an afternoon seminar, for example.
And then there's training which is going to increase the productivity at work, and training for personal development. Again, I make a distinction with that. And then there's mandatory training, which again, now the new law has provided for it.
Which is a very interesting point.
Before it wasn't catered for in law. Now if it's something, if for example you're handling food and there's specific health and safety training, food training you need to go to, that's something the employer that needs to cover for you.
And it needs to be done during working hours now as well.
Yeah.
So,
we've seen changes there as well, which is very interesting.
Thanks, Ros and
Thank
Edward,
you.
for
Thank
that.
you.
I think it was a very interesting topic. Mentioning contracts, we didn't really go into the financial side.
No. Leave that to you.
We,
Make
because
sure you have
obviously,
the salary in the contract, by the way.
Yes, that's one of the important points.
yes, the salary obviously has to be part of the contract, but we typically will be discussing the salary and negotiations and understanding how the salary works in financial literacy. And this is also training we actually offer to employers that they can give to their employees as part of their development programs. But if I could take two takeaways from this discussion we just had, I think the important one is to be transparent with your cards on the table and be clear with your employer all the time on various aspects, and also to seek advice and negotiate on terms in the contract. And remember that negotiation is not purely about the number, about the wage and the salary, but it's also about other conditions at work and even post-work contract. On this note, I'd like to thank Roselyn from 10 Years Legal and Edward from 𝗟𝗶𝗀𝗁𝗼𝗺𝗺𝗺𝗺𝗺𝗺𝗺𝗺𝗺𝗺𝗺𝗺𝗺𝗺😔 I need to, for this episode, I need to, and with pleasure, thank also the sponsors and the partners of this podcast, including the VOPS scheme and the Ministry for the Voluntary Sector. And thank you for joining us in this episode, when we'll be meeting again in the next episode to discuss the difference between self-employment and employment and freelancing. So do continue following our social media, the activity there with all the content related to entrepreneurship, financial literacy and work readiness. So until next time, thank you.